Order. Welcome to today's session of the Select Committee on Business and Trade. I'm very grateful to Gareth Thomas and Heidi Alexander for joining us to give evidence in this second session on the Post Office redress schemes. And thank you very much for bringing two officials with you, Carl Cresswell and Ed Lillington. You're very welcome. As some of you will know, there is legal action underway, and it is therefore we're therefore very grateful to the Speaker for granting the work of this committee a sub judice waiver, which I will now read. In December 2022, Mr. Speaker exercised his discretion in respect of matters sub judice to allow reference to these proceedings as they concern issues of national importance. That waiver is ongoing and applies not only to speeches made by members on the floor of the House, but to remarks by both ministers and witnesses at today's oral evidence session. Nevertheless, members are urged to exercise caution in what they say. Members are also urged to bear in mind that Sir Win Williams' Post Office Horizon IT inquiry is ongoing. Heidi Alexander, perhaps I could start with you. You're a newish minister coming into the department. You're looking at the Horizon Conviction and Redress Scheme and other matters. Can you just start us off by telling us what you have found as you have looked at the redress schemes that are in place?
Yeah, so certainly my responsibility, thank you Chair for inviting me to come along, I should say that to start off with. My responsibility in the Ministry of Justice relates to writing to individuals who need to be informed that their convictions have been quashed by the legislation, and obviously Minister Thomas from the Department for Business and Trade is responsible for the running of the various compensation schemes. So when I walked into the department on the 8th of July, I was very quickly briefed by Ed and his team of officials about the work that he was doing to be able to ascertain the individuals who had had their convictions quashed. And so that has really been my focus about how we can swiftly identify those individuals, write to them if we need further information to ascertain whether they do fall within the scope of the Act, making sure that we're communicating with them quickly, and that has been the process that has been underway in the last couple of months.
And have you come in and basically observed a machine that runs smoothly like clockwork?
So we did encounter some difficulties in July in terms of discrepancies between the various data sets that we were using to identify individuals who had convictions that were in scope of the Act.
Any discrepancies?
So perhaps if it might help, Chair, if I describe what the process has been to identify these individuals. So far we have assessed 87% of the individual cases of which we are aware. I'm going to come back on the performance stats in a minute. I'm just kind of interested in this point you made about discrepancies in record keeping, because you obviously published new figures last night that showed that the number of total convictions has gone up to 1,807. That's quite a big leap from the previous number of 1,491. And so I suppose the committee is concerned about whether there's a comprehensive list of who's been prosecuted. So when you came in as a minister, was there one comprehensive list of who's been prosecuted or not? We had been provided information by the
Portcullis House, the Thatcher Room. 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 Portcullis House, the Thatcher Room.
And was installed in the branch at the point at which that individual was charged with committing an offence. And so in order to ensure that we knew that all 5 of those conditions had been met, we had to check multiple data sources. So that included court records, it included the Police National Computer, some of the time it included HMRC and the Criminal Cases Review Commission, because we had to assure ourselves that that those individuals had convictions that were in scope of the Act. In July, we did identify some discrepancies between the Police National Computer and court records, and because court records are the definitive record of a criminal conviction, we chose to request all of the court records so that we could be sure that the individuals that we were writing to were in scope of the Act. I should also just say, Chair, that at every stage of this process we have sought to limit the burden that we are placing upon individuals who have been affected by this miscarriage of justice, because I realise that it would have added insult to injury to be constantly asking them for more information, and so we have sought to do as much of the work as we could ourselves in the Ministry of Justice, but it has meant cross-checking multiple data sources that span over many decades.
Just give us you said that some of the data was contradictory. Can you just give us a flavour of the kind of contradictions that you bumped into?
Yeah, so on the Police National Computer, the date of the offence or the offence type might not have matched the court record, and that was why we chose to request all the records from the courts.
It sounds like there wasn't a single list of everyone who had been prosecuted. It sounds like there was quite a big chunk of a list, but then you've had to basically patch data from several bits of the state to get the information you need. Is that?
That's completely right. We've essentially been piecing together the bits of a jigsaw puzzle.
You've been piecing together the bits of a jigsaw puzzle?
That's how I would characterise it, yes.
Do you think that you've now got all the pieces of the jigsaw puzzle on the table?
So it's possible that a further individual could come forward and say to us that they believe they are in the scope of the Act, but we are confident that the vast majority of people who do have convictions that are in scope of the Act that we are aware of, but it is not impossible that somebody else could come forward and that we're unaware of at the moment.
So you can't tell the committee today that you are 100% sure that everybody who should be on the radar is on the radar?
At the moment, it's not inconceivable that somebody could come forward still, but I am confident that the vast majority of people who have convictions that are in scope of the Act we are aware of, and as I said, we have assessed 87% so far of those cases.
So I just want to double check these numbers. So as far as we understand it, there's a total of 1,103 individuals who are either being considered or have been considered across England, Wales, Scotland and Northern Ireland. Does that sound broadly right?
So the figure that I have, Chair, is that the number of individual cases that have been or are being considered is 949, and I could always ask Ed to comment in detail on how we have arrived at that figure.
Ed, does that 949 include?
No, that's only England and Wales.
Okay, so if we were to add Scotland and Northern Ireland?
So Scotland and Northern Ireland, they are conducting that casework themselves. So the figures that I've got for them is that Scotland said that originally, this is from the 31st of October, they had 141 cases that they were looking at. 44 of those they had identified as being out of scope. As of that update on 31st of October, they had identified 31 who were in scope of the Act, and they were assessing the rest. Northern Ireland, their update from the 26th of September, which the committee may have seen, suggested that they had identified 12 that were quashed and 14 that they were still considering.
Right, so that would basically take us to 1103 or thereabouts. So that's the number of cases that are in scope. There's then, I think, 565 people who have been identified as having one conviction quashed. Is that correct?
So if the number that I have for England and Wales is 522.
Okay. That's obviously a much smaller number than 949.
Yep, correct. And so there are 145 individuals who we have written to ask for more information, and there are 155 individuals in England and Wales who we have assessed and have confirmed that they have no convictions that fall within the scope of the Act. And that 155, I can break that down if you would be interested.
Well, I think the question is, if there's 949 people who are you think are in scope of the scheme, only 565 have been identified as having one conviction quashed. When is everybody basically going to know that they've had their convictions quashed? What's the timescale that you've set for your team?
So it's my understanding that we will have carried out all of the assessments by early January on all the cases that we are aware of. There are a cohort of individuals whose convictions fall outside the scope of the Act, and I can further break that down for you.
Yeah, I'm more interested in why there is this gap between the number of people that you've identified and the number of people who've had a conviction quashed, but you basically told us today that you are working those through, and that's going to take you until January to get done.
There are a small number of cases that we are still working on, yes.
So in terms of the claims paid, if we just bounce to that end of the process, although we've had 565 people who have had a conviction quashed, they've been identified as such, I think in total there's only 183 claims that have been paid, either interim or full. So I think the question we're keen to understand and answer to is, if you take until January to assess everybody, how long is it then going to take to pay everybody?
I think that might be a question that Minister Thomas can answer.
Okay. Well, Mr. Thomas, maybe I can start then with just your basic assessment of what you inherited when you came into the department, when you looked at the redress schemes that were in place. What were your observations?
Well, I think it'd be an understatement to say that there's been considerable criticism of the compensation process, that many of the sub-postmasters who were victims of the scandal, who I've spoken to, have criticised the speed, have criticised the number of requests on occasion that they have been asked for extra information in order to help judge their claims. And there have obviously been criticisms about the extent of legal involvement and delays around the use of lawyers to judge claims.
You must have got like all these civil servants and the post office people together when you were appointed. What were your kind of observations once you'd kind of met and spoken to them? Has the Department of Business and Trade got this clockwork machine that is running the redress programs that you thought, oh great, this is fantastic, just got to run this machine and off it will go?
Well, to start with the issue that you've just been discussing with Heidi, we inherited a system where after the last Parliament had taken a decision to overturn all the convictions of sub-postmasters, none of the details of the compensation process had by the time of the election been sorted out. Mm-hmm. That was left to us to sort out.
None of the redress.
So the redress scheme, to the process of giving compensation to all those who are identified as having had a conviction and to having had that conviction overturned by Parliament in the legislation that we voted for in the last Parliament, a compensation scheme hadn't been set up for those individuals by the time of the general election. So those details have been left to us to sort out, not only to find out who those individuals are, but then to begin the process of getting compensation out to those individuals.
What about the other schemes that you inherited? How fit for purpose were they?
So I think on the overturned conviction scheme, I think we are making a reasonable progress in getting redress out to the victims who are covered by the OC scheme. On the GLO scheme, which I'm sure we'll come to, we are confident now, having talked to the claimants' lawyers, that all those claims that come in before Christmas, that we will be able to get substantial redress out to by the end of March. If I'm honest with you, Mr. Byrne and the committee, the scheme I'm most worried about is the Horizon Shortfall scheme, where there are still people coming forward, even at this point, and in a sense that is a good thing. The victims of the scandal are having the confidence to come forward, but the numbers of people we're seeing in that scheme who will need compensation is continuing to rise. It's one of the reasons why we introduced the fixed sum payment of some £75,000 into the Horizon Shortfall scheme to try and help those coming forward who perhaps thought their claims were at the lower end, relatively lower end, still significant, but at the lower end, to get quicker redress.
It sounds like it's a mixed picture. There were some schemes where there wasn't anything, some weren't working perfectly, some you had more confidence in. Was it your basic analysis that the schemes were not running fast enough?
My basic analysis is that we've got to do more to get redress out of the door more quickly.
You're saying they're not running fast enough?
Well, certainly I want, given the numbers of people who still to have compensation when we came into office, absolutely I want to speed up the process.
That's a yes. Winton.
Great, thank you very much, Chair. We've touched quite a lot on England and Wales. I just want to touch a little bit on Scotland and Northern Ireland just now. Can I ask how are you working with the Scottish Government and the Northern Ireland Department of Justice to ensure swift justice for the sub-postmasters?
Yeah, so the Act introduced by the last government, as you will know, did not include convictions that were imposed in Scotland. Justice is obviously a devolved matter, and the government at the time took the decision for responsible ministers to remain accountable for the decisions taken in their jurisdictions, and you will know that Scotland has historically had a separate legal jurisdiction to England and Wales. We have been working through our casework teams very closely though, and officials in the Ministry of Justice have supported the Scottish Government as they have progressed their legislation, and we continue to support them in the implementation of the Act. Ed might like to say more, but it's my understanding that our casework team shared our casework guidance with both the executive in Scotland and in Northern Ireland, and that there are regular meetings so that we can share best practice.
So are you saying then consistency then in how that's been rolled out and how people are being dealt with as a consequence?
Yeah, it should be. So we shared the casework guidance with them that we had developed to allow them to base theirs on that. And similarly with the legislation for Scotland, because obviously Northern Ireland was included in our legislation, we shared all of our instructions and legislation with them to allow them to develop that act. So the aim was consistency.
Yeah, great. And from what you've seen, do you have any specific concerns of what's happening in Scotland or in Northern Ireland?
Not to my knowledge.
Ed?
Not from my perspective, no.
Can I just check, actually, Heidi, how many civil servants do you actually have working on
22.
this? 22.
Yes.
Is that enough?
I've asked that question, Chair. I asked it back in July, and I also requested a weekly progress update as soon as I got into the role, because I recognised that this was going to be a massive priority. I am confident that the resource that we have dedicated in the Ministry of Justice to the casework function is enough at the moment, but it is a complicated process, as I explained to you earlier, checking multiple data sources, writing to individuals, getting responses back from individuals, considering that information. We won't be closing down this process in the Ministry of Justice. If anyone did happen to self-identify later in January, we would make sure that the resource is there to be able to swiftly make an assessment of whether they fall within the scope of the Act.
If you had more people, could you deliver your January deadline earlier?
No, there's certain things that we are waiting for. So at the moment, the casework team is waiting for a return from the credit referencing agency, Equifax. because some of the problems we've encountered is we simply don't have addresses for 61 individuals, and so there have been lots of different routes that we have pursued to try and get those addresses. We are waiting for one of the returns to come back, and so I don't believe that the number of staff that we have allocated in the Ministry of Justice is the primary constraint. If it was a case of putting more staff and we could do this more quickly, I wouldn't have hesitated to ask Ed to have made those changes.
And if you look in peril of missing that January deadline, will you put more staff on the job?
If staffing proved to be the constraint, I would, of course, consider extra resources, but we have now assessed 822 out of the 949 cases that we are aware of in England and Wales, and so the vast majority of the work has been done. We are starting to come to the end of the road in terms of actually trying to find some of those addresses for the 61 individuals that I talked to you about, but of course I wouldn't hesitate to put more staff onto the job if I thought that that was going to speed up the process in any way.
Money's not a constraint on getting the job done.
No, we've made it a priority in the department.
And then in Scotland and Northern Ireland, have we now confirmed that all individuals who may be in scope of the Act have been identified, or are we still looking for people?
Ed, do you want to pick that up?
So the casework teams in Northern Ireland and Scotland are working with the prosecutors there to identify who those people are. And so they will, similarly to the way that we have with the Post Office and CPS, been given that list. They're also working with the Post Office to identify them. So to the best of their knowledge, they have the people that they need. But as Mr. Alexander said, there may be more people who come forward as a result. So yes, for now, I think is the answer to that.
What is it writing?
The Horizon shortfall scheme is the only scheme that doesn't offer paid legal advice when submitting a claim. Why don't you offer this help to claimants at the point of contact for this scheme?
I think that's probably a question for me.
Indeed.
Yeah, sorry.
It's in the House. Order. The session is suspended. We will resume after the division. Order. Welcome to the resumed session of our hearings on the Post Office and the Post Office redress schemes. Gareth Thomas, Rosie Writing was just asking you about why, when you looked at the HSS scheme, there is not paid legal advice available up front. That's been a big criticism that we've heard during our inquiry. You yourself said that you were not happy with the way HSS was working. You were worried about that. Why isn't there help up front to help claimants with the HSS scheme?
So there is legal advice available to people who choose to put in to ask for a full assessment of their legal claim.
I think that help is available once the claim has gone in, no?
Once they put their claim in, absolutely.
Yeah. And the question is, why isn't it available before they put the claim in?
So our sense is that people will want to begin the process initially of making a judgment as to how big and wide their claim should be. Once they bring their claim forward, then advice can be made available. What we've wanted to do as well, though, is to give another route for people to get swifter redress, and so we've introduced a fixed sum payment of £75,000, where there's been considerable interest from people to try and get quicker redress. People are essentially then have a choice as to whether to opt for the fixed sum payment or to have a full assessment of their claim.
The challenge, as you'll know, I mean, Jill Donaldson was a good example who gave evidence to this committee. And when she first applied to the scheme without legal representation, she of course thought that the initial offer was fair. But of course, it was only when she acquired that legal representation to get the claim right, she discovered that the claim that she should have been entitled to was much, much bigger. So there's a real peril here, which is that one, people are so intimidated by the process they just don't dare go forward. And two, when they're putting their applications in, they're not necessarily putting their best foot forward, and so the offers that come back are unfair. And we also heard just clear evidence that this kind of miasma of confusion at the beginning of the scheme is slowing the whole thing down. So again, ask you, why aren't we just looking at this anew and putting in place legal help up front before the claim goes in?
Well, so we've looked at the Horizon shortfall scheme and looked at what we could do to try and speed the process up and begin to address some of the questions about that people have had about the fairness of the offers they've had through the Horizon shortfall scheme. So the fixed sum payment is an attempt to offer quicker redress for a significant number of people. But we also made a commitment shortly after we were elected to set up a Horizon Horizon shortfall scheme appeals process, which I believe was one of the recommendations of this committee in the last Parliament, which will provide another route for people to challenge or have a proper independent look at their claim going forward.
But the challenge is that people are now getting caught and mangled in the process rather than getting the claim and the claim submission right up front. What is stopping you? I just want to zero in on this. What is stopping you providing legal aid or legal assistance when people are actually drawing together their claim at the very, very beginning of the process? What is stopping you?
Well, Mr. Byrne, I'm quite happy to look at any recommendations that the committee want to bring forward in this regard. As I say, our instinct has been that there are people who are victims of the Horizon shortfall scheme who want to avoid a longer process, and that therefore the fixed sum payment is a way to offer quicker redress to those people. There are every victim's experience has been very different, and there are many people who do want to have their claims fully assessed. They do some of the initial preparation and thinking about their claim. They put that in. They then get legal advice to help prepare their offer if they want it. And as I say, we're introducing a further check, a further route, a further independent route to get to be able to make a judgment as to whether people are being offered a full and fair settlement by setting up an appeals process,
which we'll come on to. But let me bring in Alison Griffiths.
So just to follow up on that, how do you think that claimants can make that choice between the different schemes and to understand whether the schemes are fair without access to that legal representation?
Well, I think many people will choose those, for example, to continue down the Horizon shortfall scheme in particular. Many victims will decide that they do want a full assessment of their individual circumstances and how much compensation they're entitled to do so, and they're fully entitled to go down that route. They will give some initial indications of what they think they suffered. They're then entitled to get legal support with their claim to go forward, and their claim gets fully assessed as a result. And if they're not happy with the offer that they're provided with, there will be an appeals process, which we're in the business of setting up to provide that additional safeguard.
And I think the question that both the chairman and I are trying to ask is why we wouldn't put that support, that legal advice up front at the very beginning of the process in order to allow people to make a choice before they have to go through the process of submitting, i.e. doing the full 600,000 or the 75,000. They're not being able to access advice on which of those is best suited for them. So sorry, that's a long-winded question, but
just to be clear, there's under the Horizon shortfall scheme there is the option of a fixed sum payment of £75,000.
Yes, but how would they know which to take?
So the offer of a fixed sum payment of £600,000 is available under the HCRS scheme. So it's a different scheme. And your eligibility for HCRS is determined by whether you had a conviction that's been overturned by Parliament. So as soon as someone receives a letter from the minister through the Ministry of Justice route or one of the devolved administrations, they become eligible then for HCRS and potentially for a fixed sum payment, and they have access to legal advice.
Let's just stay focused on the HSS scheme, because that's the line of questioning. I think what you're saying is that your ears are open to recommendations from the committee about how we can improve legal support at that stage of the process. It sounds to me like you haven't provided that at the moment because you don't think it's needed.
Well, our sense has been that there's significant interest in the fixed sum payment route, and that people can make a decision themselves as to whether or not they want to go down the route of taking the 75,000, or whether they want to have their claim fully assessed.
Could I also add that the origin of the Horizon Shortfall Scheme was obviously the settlement deed in December 2019, where the JFSA and their lawyers sat down with the Post Office, and what they were trying to design through that settlement deed was a process that was not full of lawyers, on the grounds that some of the claimants wanted the speed. They didn't want necessarily lots of lawyers getting involved. So more lawyers doesn't necessarily mean speed.
Well, we've got, amongst late claims, 1,762 claims received, and only 13% of those have had offers. So I'm not sure anyone on this committee would say that process is moving especially quickly, Mr. Cresswell. Antonia Bance.
Thank you. So staying with the Horizon Shortfall Scheme then, the claimants who we've established don't have legal advice at this point. They're telling us that the application form is very, very complex. So can you tell us what you're doing to improve this part of the process, please?
Yes, of course. Yeah, this is a piece of feedback that we've heard strongly from the committee and elsewhere, and we've been working with the Post Office, who have taken steps to simplify the application form so that it is more user-friendly in response to feedback that postmasters have provided to them. We've also tried to learn the lesson in relation to the application form for other schemes, including the Horizon Convictions Redress scheme that the Minister just mentioned.
I think just to add to that, I mean, we have made clear to the Post Office that they need to be working with us to help find solutions to the challenges around the Horizon Shortfall Scheme. We have encouraged the Post Office to write out to anybody who they think might be a victim and might be eligible for the Horizon Shortfall Scheme. So we are seeing more and more people continuing to apply to the Horizon Shortfall Scheme, and that's part of the motivation for wanting to give a fixed sum payment option to those whose claims are perhaps lower than some of those whose cases are more complex and where they've clearly suffered substantially worse harm.
Simon Recaldin obviously told the Wynne-Williams inquiry on the 4th and 5th of November that 47% of those going through the HSS found it hard to understand. Are you basically saying to the committee that the process, the claims form, is now simple enough, or does it require further work?
Well, we've certainly tried, as Mr. Cresswell set out, to encourage the Post Office to make it simpler. As I say, 4 months in, very, very happy to listen to advice from the Select Committee, and obviously from the inquiry. We are having regular conversations with the claimants' lawyers direct to understand if they've got concerns about the forms. They've certainly been very helpful to us in pointing out issues for us to address in other schemes, and we'll continue to talk to them about the forms.
So you're open to continuing to simplify the process?
Absolutely.
Okay, Sonia Kumar.
This is to the Minister, Gareth Thomas. Dr Hugel highlighted that there's large discrepancies between the first offer that was being given to the revised offer to HSS, including that went from 4,000 to 133,000. Is the scheme designed to reduce the cost rather than give claimants the offer they're entitled to?
We've been very clear. We want to make sure that people have the opportunity to get full and fair compensation, which is one of the reasons why we took the decision to introduce in part following the recommendation of this committee in the last Parliament, an appeals process to help claimants have confidence that they have been able to go through the whole process and be confident that they've got a full and fair settlement. But equally, we've also heard very loudly, very clearly, the criticism about the pace of compensation. And so the introduction of a fixed sum payment of £75,000 is designed to help those who don't feel that they need or who don't want, for whatever reason, to go down a full claims process to get access to fair compensation more quickly.
Do you think there's any barriers for this application for those that might have disabilities, those that don't speak English and that may be their second language, that maybe you may need to address?
Well, I think there are, having met now a series of victims of the scandal, there are many people who've been through, considerable trauma as a result of the way they were treated by the Post Office. So there are many challenges that many claimants speak to us about in terms of accessing the compensation process, and we're trying to, as much as we can do, to simplify the process and make it easier and give people a quicker route to get compensation. But absolutely, I wouldn't want to come before this committee and say that we're not open to further thinking. We absolutely are. It's one of the reasons why we have regular dialogue with the claimants' lawyers to discuss issues that they've picked up and are picking up directly themselves in the way they're dealing with things, but also issues that they're picking up from their clients.
How have you simplified this process for people to apply for this application?
And obviously the option of the £75,000, as we've talked about quite a lot, is a very clear simplification, and work has gone on with the Post Office to improve both the form, as we touched on earlier, and the guidance to make it easier at the point of use. I think on your point around the disparity between the offer and the final settlement, where someone like Dr. Nigel has been involved, that's an illustration of the fact that there is that legal support to provide help for people who are unhappy with their first offer. Obviously those first offers have come out of an independent panel, not from the Post Office, and the legal support helps ensure that the claimant has that conversation with the Post Office.
Perhaps one of the other concerns, just to flag, that we've heard is that certainly in earlier iterations of the Horizon Shortfall Scheme, it was a very adversarial process for that some people experienced. And we've certainly made clear to the Post Office that we want claimants, as much as is possible, to be given the benefit of the doubt, and insofar as it's possible to do so, for as generous an offer to be made as is possible.
And you've communicated that preference for the benefit of the doubt to your lawyers, have you?
We've certainly made it clear to the people working for us on our schemes, and we've told the Post Office that directly as well.
So Herbert Smith have been instructed to give people the benefit of the doubt.
Well, we have encouraged the Post Office to look afresh at the support they're getting from lawyers, and I've made clear to the Post Office that they need to look at ways to speed up the process.
Have Herbert Smith been instructed by the Post Office or by you to give claimants the benefit of the doubt?
I can confirm that is the case, and the independent panel too that operates within the Horizon Shortfall Scheme has been given that instruction, and they have the discretion and the urgency of providing the benefit of the doubt. So yes, that runs through the instructions for the HSS scheme.
We will check with them that they've heard that message. Matt Weston.
Thank you, Chair. Mr. Just to pick up on you rightly said that you want to speed up the process, you're open to ideas and so on. And it's clearly complex, I think, for so many of these applicants. What merit would there be in having some sort of online calculator? You think about pension credit, you think of so many other forms that government has introduced where it would simplify and give them some visibility of what the parameters might be for them given their particular case, rather than having to go to lawyers or just accept the 75,000.
Yes, of course. I mean, for the GLO scheme and for the HCRS, the Horizon Convictions Redress scheme, both of which are run from DBT, what we have done is published principles and bandings of indicative amounts that a victim might be eligible for when they apply for compensation. So we've partly tried to respond to concerns about a lack of transparency about what might be a fair outcome for the claimant by including that within the guidance that we have published. That doesn't exist on the Horizon Shortfall scheme, I acknowledge, but on the schemes that DBT is running, we've tried to, with the support of the advisory board, make that information more clear.
That could be bespoke to the individual.
Well, you're quite right that every individual claim is very much dependent upon the individual circumstance. So our guidance is not the calculator that will take a person's individual circumstance and then turn it into a particular number. It gives broad indications by different heads of loss.
All right, Edwards.
Thank you, and thank you, Minister Thomas, for that information. I think we've talked quite a lot about the speed and the complexity of the process, and we've heard in previous sessions about the assessment panel and how it feels that it's overstretched and not getting through the cases quick enough. Certainly, it was cited previously that people have been waiting 20 years to get to this moment. So I recognise that we have made some progress, these things are there, but what else is being done to try and get that flow through the system to get those cases moving in a faster way?
So I suppose there are a number of things that we've done. The introduction of fixed sum payments is definitely one thing that we think will help significantly to speed up victims getting access to fair redress where it's appropriate for them. We have introduced a whole new compensation scheme following the decision of Parliament in the last session to overturn the convictions of all those sub-postmasters who were sent to prison as a result of the Post Office. That compensation scheme wasn't in place. And we've sought to learn some of the lessons, as we've touched on, from some of the schemes that have been in operation for quite a long time to try and make the HCRS scheme work better. So one of the criticisms in the past has been that people have been asked for information that they don't have access to. Well, we're trying to make sure that that isn't their experience or that's not the experience that victims face when they're going through the HCRS scheme, that they're able to be upfront about what they don't know in terms of their circumstances, so that we, I say we, the royal we as in the compensation process, doesn't put additional pressure on them to somehow come up with that information, and then we're trying to, insofar as we can do, in line with the principles of the scheme, to be as to give people the benefit of the doubt and to be as generous as we can do in the offers that we bring forward.
Thank you. What we also heard in our previous session was around the sort of potential delays that are being created, or obfuscation tactics that are being used. So it's sort of like a queue that's being created for the assessment by the panel, rather than going through a mediation process. So are you aware of that, and can you explain why that might be happening?
Yeah, so on occasion I think the criticism has been that requests for additional information have come quite late in the process, in the sort of 40-day process, and that is a criticism that we would accept, and we're looking at speeding that up. When we ask for additional information now, we're asking for additional information in order to try and give a more generous offer, and that's the motivation going forward. But I recognise we need to try and do that perhaps earlier in the process to avoid creating the sort of frustrations that there have been going forward. That's an issue that claimants' lawyers have said to us very directly too, and we're looking at what we can do to speed things up. So specifically on the GLO scheme, it's perhaps worth saying that we've moved in additional staff directly within the department in to help with assessment of those claims, and encouraged Adelshaw Goddards to put extra staff in as well.
Okay. So there's 1,400 outstanding claims on the HSS. Offers being made by an independent panel. That's sitting twice a week, 8 to 10 times a month. Neil Hudgell reckons that that's going to take 18 months to get all the offers out. Is that your assessment?
I certainly hope it isn't, but as I said earlier in my remarks, this is the scheme, the compensation scheme that I'm most concerned about. So we are talking actively to the Post Office about what can be done to speed the process up. It's one of the reasons why we're trying to take some of the pressure off the scheme by making sure that the appeals process that will be linked to the Horizon Shortfall scheme is run not by the Post Office, but is run directly in-house and is a completely, well, not a completely separate process, but is a separately administered process going forward.
Thank you. John Cooper.
Thank you, Chair. Sticking with the HSS scheme, Minister, you've talked about the fact that it was originally designed in an adversarial manner, and you've talked as well about the danger of everybody lawyering up. We had very strong evidence that something that might be welcome was an independent adjudicator who could give case management directions throughout the process. I believe that Sir Gary Higginbottom in the original overturned conviction scheme fulfills that role. Is that something that you think might be helpful with the HSS to try and move this forward? Is that something that's been considered?
So, if you'll forgive me, it's a good moment to mention that Sir Gary Higginbottom has just been appointed as the chair of the HCRS appeals process again, as well. So again, helping us to make sure that the newest compensation scheme learns from some of the lessons of past schemes. On HSS, there is an independent process, and we think with the appeal process that we're bringing in, that will also help to give more confidence to people that the process is working for them. But as I indicated, we're talking to claimants' lawyers on a regular basis and looking for what we can do to improve the Horizon Shortfall scheme, because it is the scheme where, as I've said, I have most concerns about at the moment.
Weston.
Thank you, Chair. Minister, you mentioned just a moment ago about the request for information, and that on many occasions you're seeing these requests coming in around 36 days ahead of the 40-day cut-off, and then this resets. If we're trying to speed up the process, would there be, do you believe there'd be merit in having a reset not of 40 days, but of fewer than 40 days? Otherwise, this can become a systemic problem.
On the GLO scheme in particular, this has been flagged to us as a significant problem. So
we're certainly aware that what has happened on occasion, the requests for information have come late in the GLO process after a first offer has been tabled. So when the challenge process kicks in, we're also happy to be held to account that 90% of challenges will be responded to within the 40 days process as well. So I hope that is an additional bit of accountability to put pressure that will help hold our feet to the fire to meet the concerns of those in the GLO scheme. Certainly from the conversations we've had with the claimants' lawyers for most of those in the GLO scheme, we're being told that they're expecting to put in by Christmas most of the claims, and we think we're reasonably confident that as a result we will be able to get first offers and therefore significant compensation out to all those who put claims in by Christmas by the end of March.
Any events?
Thank you, Chair. Again to you, Gareth. So we've just heard you say that you want claimants to be given the benefit of the doubt and that offers should be as generous as possible, and that you have instructed lawyers for DBT and instructed the Post Office's lawyers to act on that basis. But we are still being told, and we were told a couple of weeks ago by claimants and their lawyers, that DBT is overly forensic in its approach to assessing cases. We heard Minister Alexander say that continued requests for information were adding insult to injury to the victims of this scandal, and very much appreciate your comments on that perception of overly forensic.
Well, we're certainly trying to avoid that perception, and as I say, we're trying to be as generous as we can do, and the motivation for requests for additional information is to enable us to make it a more generous offer. We're certainly, depending on the scheme, wherever we can do, we're making interim payments, and certainly where we've been told that there are particular issues around hardship, we've also been seeking to make hardship payments to ease the particular circumstances that people face. I am acutely aware of the trauma many sub-postmasters have gone through as a direct result of how they've been treated by the post office. So we are actively wanting to make the process as better as we can do, and as genuinely we're open to any ideas that will make the process both faster, fairer, and reduce the stress for those bringing compensation claims forward.
And I'm sure we will pick this up in our report and in recommendations to yourselves, but I think perhaps having heard what we've said today and having heard the evidence of the session 2 weeks ago, there might be some leadership that could be applied internally in the department and in the post office to ensure that the instructions have been fully appreciated.
Well, just to be clear, we've delivered that message in a significant way to the post office. Where one of the reasons why we actively have introduced fixed sum payments is to try and make the process easier for a relatively large number of people. We meet on a regular basis with claimants' lawyers to understand ongoing cases, both around particular cases or particular groups of cases. But we're always looking to improve.
Rosie Writing.
Thank you, Chair. In a previous session, Denton's has been described as a highly paid postbox.
A highly
paid postbox. What value do you believe they're adding to the GLO scheme?
Well, they're our independent advisors. So, and that they help independently assess the claims to move things forward. So we believe they play an important role. And as I say, in terms of the GLO process, I think certainly from the conversations we've had with claimants' lawyers, we're hearing that the vast majority of the remaining cases in the GLO group are likely to be put in by Christmas. And we believe that we will be able to make substantial offers and make substantial payments potentially interim payments, but nonetheless substantial payments of compensation by the end of March.
I would add to that briefly that I've also appreciated Denton's support in establishing and helping run the independent panel in the GLO scheme, and they also harry people and bang heads together to try to encourage pace within the system in a similar way that Sir Gary Hickenbottom does on OC. So Denton's do play a bit of a sort of case management encouragement role within the GLO.
Bring in Alison Griffiths quickly, but you've just published a PQ answer in the last couple of hours that shows that your legal costs for the GLO scheme specifically are £15,410,000. Now, this is on a scheme that has issued £106 million in redress payments. The implication is that £1 in every 7 is being spent on lawyers. That's why these questions are about whether there's a grip on the lawyers. And I wondered whether you thought that legal bill right now was good value for money, given how much in redress payments has gone out the door.
Well, what I would say to you, Mr. Byrne, is we are working at pace to try and get more compensation out of the door to more victims more quickly. We do need access to legal advice to help us do that. There's more we need to do. We recognise that, and some of the measures that we have taken since we came into office are designed to help us do that. but we do need legal support to do that.
Could I also just give... Does that ratio need to come down, £1 in 7 on lawyers compared to redress payments?
There's a factual point that is important to say about that 15.4 million. Most of that is for the claimants' lawyers. So 12.5 million of that 15.4 million is for some of the people that you saw who gave evidence 2 weeks ago. The spend on DBT-related lawyers is 2.9 million on the GLO within the 15.4 million, so about 5% or something, which we try to manage from an efficiency perspective. But we aren't trying to reduce the amount of money that goes to claimants' lawyers because they need the support to engage with the schemes.
Arguably, if the scheme was simpler, the lawyers' bills might be lower.
Of course, but it's important that they get access to the support that they ask for.
That's incredible.
It was just going back on the request for further information, your statement that this is always done with the intention of improving offers. I wanted to know how many examples there are of occasions where you have actually reduced the offers made.
Appreciate that might be something you want to write to us on.
That might be best. Normally the OFI is there purposefully to increase an offer rather than the other way around.
It was really about the trust. The question was really about the trust of participants in the scheme. What we heard in the last evidence session was concern about giving more information, that it was actually going to be detrimental. So that's why I'm asking the question whether it has been detrimental on any occasions.
I would certainly hope not, but let me write to the committee.
Feel free to follow up. Thank you. In writing.
And forgive me, Mr. Byrne, actively now we want those requests for further information to help the claimants. Absolutely, there are. We have a responsibility for public money, but the overriding imperative is to make sure that those people who we know have been victims of the Horizon scandal, that they get as full and fair a settlement as is feasible.
Thank you, Sarah Edwards.
Thank you. Sir Alan and other individuals told us that they were quite unhappy with how their claims were progressing and that no claims have yet gone to Sir Ross Cranston. Could you explain sort of why or what the process is, and that means that Sir Ross is only able to look at a claim at the end of the process?
Well, we were discussing earlier the merits of having someone independent who can look at claims, and so Ross is at the end of the process. He's the independent person on the GLO scheme who can look at whether claims have been prepared in a fair way, and we think it's right on the GLO scheme that we have him in place. There's a similar role for Sir Gary Higginbottom now on the HCRS scheme going forward. And then on the GLO scheme more generally, as I've alluded to, from the conversations we've had with claimants' lawyers, we're expecting the vast majority of the remaining cases to be with us by Christmas, and that as a result we'll be able to make significant offers to those claimants and substantial redress paid by the end of March.
Thank you.
Why have so few cases gone through to Ross?
Largely because they've either been settled at the initial offer phase or at the challenge phase. At the moment there are about 40 challenge cases within the 492, so about less than 10% of the overall cohort are currently in that challenge phase. So they either are resolved at initial offers or at the challenge phase, or via the independent panel, albeit only 4 cases so far have gone to the first independent panel. So
as you'll know, there are lots of disputes about the fairness of the offers, and when we're looking at the role that Gary Higginbottom plays in the scheme that he helps with, the question is why Ross Cranston is not given a similar role and similar powers to try and bring forward a breakout of goodwill to get these claims settled faster. You've got some very, very high-profile cases still outstanding.
And I'm sure that Sir Ross will play a bigger role than he has hitherto, but we have found that the independent panel is a good source of support for claimants once we can get to that point with claims going through.
Not what GLO claimants are telling us.
Well, as I said, we've only had 4 cases go to the independent panel, so the sample size for commenting on that is quite small. But
that's why the question is, shouldn't Ross be given a much bigger role to try and broker settlements earlier?
Well, the conversation we're having with Freeths and others is whether Dentons can play a bigger role in that early stage.
You think Dentons will do a better job than Sir Ross Cranston?
I think there's a question of balance between the two. We can have both Sir Ross doing his review role at the end.
He's not doing anything at the moment because no cases have gone to him.
No, but I'm sure that more will over the coming weeks.
Matt Weston.
Thank you, Chair. Mr. Thomas, what specific instructions have you given to your lawyers to make sure that sub-postmasters are getting fair and fast offers? And what specific metrics are you applying to ensure that swift and fair process is being achieved?
Well, there are a set of published guidelines, as we've made clear already, and we expect the teams who are looking at cases that are brought forward to work according to those principles. But we're also seeking, as we've already discussed, where people believe that they want to avoid a longer process, and where they're confident that the fixed sum payment is appropriate for their circumstances. We have wanted to offer that fixed sum payment to reduce the pressures on those people and shorten the process going forward. But equally, we've been clear consistently that we want as full and a fair settlement as is possible for people who are victims of what, after all, as we all know, is probably the greatest miscarriage of justice we've seen in this country. But the additional challenge is to look at ways to speed the process up, and that's what we're trying to work on as well now.
And I would add, if I may, that we recently had a meeting with the advisory board and the claimants' lawyers and asked them this question: are you comfortable that the settlement levels are fair? And the answer was that generally they felt that they were fair. The question was one of speed, which the Minister has mentioned as a priority. So we actively consulted the advisory board and the claimant lawyers on this question of fairness.
Okay. At the Wynne Williams inquiry, former Minister Kevin Hollenrake said it would be a concern, I think, just to quote, or a mistake for government to arm up with lawyers. Interesting observation for someone now in opposition as opposed to be in government. Would you agree with him?
Arming up. Absolutely, I would be very uncomfortable with that sort of phrase. I mean,
I think it was armed up.
I'm not going to sort of comment on what went before, other than just to say what I have been clear about is that we want both a faster compensation process, but one that still delivers full and fair settlements.
I mean, we can tell you what's happened before, because the total legal bill that the taxpayer has spent on lawyers for this miscarriage of justice is about £268 million.
Well, as I alluded to earlier, Mr. Byrne, we are trying to take a number of steps to speed up the compensation process, and where we've got concerns about the cost of legal advice, as we very much so have in terms of some of the lawyers that the Post Office are currently using, we've been clear to make our concerns crystal clear to the Post Office going forward.
Post Office spending too much on lawyers?
I think they could. Well, we've encouraged them to look again. Let me put it like that, at how much they're paying and at what they're asking lawyers to do. Certainly, we think some of the tasks that the lawyers are doing could be done in a less costly way.
It sounds like yes.
Yes, it probably is a yes, Mr. Byrne.
It is striking, isn't it, that the original budget was 1.2 billion, and that's been increased, but 1.2 billion. This is 268 million. That's quite a striking proportion of the total budget.
So the 1.8 billion that you mentioned...
It is now, but it was 1.2.
Understood, but the 1.8 does not include the legal fees for the Post Office or for government.
It's 1.2 plus 268 million.
It's outside the figure that... Yeah.
Sonia Kumar?
This is a question for the Minister, Thomas. So Alan Bates is calling for all claimants in the GLO scheme to be completed by March 2025. Will you put a deadline on completing the GLO scheme?
I'm reluctant to put a deadline on the GLO scheme, and indeed compensation schemes more generally at the moment. I'll come back to the GLO scheme in just a second, but I think of the experience of one of my constituents who only narrowly avoided missing the original deadline for the HSS scheme. We are still seeing people coming forward claiming for the Horizon shortfall scheme in particular. So I am wary of imposing a deadline at this point, in particular as the inquiry is still ongoing, and where I think the inquiry is helping to give confidence to more victims to come forward and put in claims. Specifically on the GLO scheme, as I've said, from the conversations we've had with the lawyers who are working with the remaining GLO claimants, they're confident that they will be putting in their full claims by Christmas, and we are confident that if they do so, we will be able to get substantial offers out to those claimants and substantial redress out to those claimants too by the end of March. As I understand it, claimants' lawyers have said to you directly that they expect full resolution to take a bit longer, but we believe we will nonetheless be able to get substantial amounts of redress out to the GLO claimants by the end of March.
And are you able to provide a time frame from when someone's put an application and when it will be completed? So if you can't give a closing date till March, are you able to give a date from when the process will start and when a process will close?
So on the GLO scheme, the accountability mechanism, if you like, by which the department is judged against, is that we have to get 90% of first offers within 40 working days, and we're confident we are meeting that at the moment. What we're also saying now is that if an offer is challenged, then we will commit to getting 90% of responses to those challenges out within 40 days as well.
Sir Alan has threatened for further action if the deadline's not set. What will you do to avoid going to court?
Well, I think it's an individual decision for people as to whether or not they go to court or not. I think it's the responsibility of government to try and make the compensation processes work as well as is feasible. We are talking regularly, as I've made clear, to the claimants' lawyers, both for the GLO scheme and more generally, to look at what we can do to speed up processes and get full and fair settlements out to people more quickly. And as I say, we're confident that for those claims on the GLO scheme that come into us before Christmas, as we're being told most of the remaining claims will do, that we will be able to get significant sums of redress out to those claimants by the end of March.
That's 209 claims still to be received. You're anticipating most of those in by Christmas. When you say a significant slice of that number settled by March, what is significant in your book?
Well, I'm not saying.
I know you don't want to put a target on it, but I mean, just give us a rough sense.
So if a first offer is made, but people are not, the individual victims are not happy with that first offer, we will nonetheless pay 80% of that first offer, which is my point about substantial redress by the end of March. I think we need to recognise that each claim has to be treated on its own merits, and we will do that going forward. I think claimants' lawyers have wanted us to make sure the process of responding to challenges is quicker, and we accept that is something that we need to do. It's one of the areas for improvement going forward. It's partly the reason for wanting to, if you like, extend the 90% by within 40 working days to challenge offers as well as to first offers.
John Cooper.
The Chancellor announced an increase to 1.8 billion, up £600 million for the total compensation package. What was the thinking behind that? Was it an expectation of more claims or of more generous settlements?
Well, as I understand it, for example, the amount of interest in fixed sum payments hadn't been taken into account in previous estimates. Certainly, the HCRS scheme hadn't been taken into account in those estimates, and that's what led the Chancellor, in discussion with the OBR, to set the 1.8 billion figure. That's not a limit. It's not a target. It's just an estimate at this point of what we think the compensation figures could be. But if we need to approach the Treasury again, then we will be able to do so.
May I also add that this reflects ministers asking the Post Office to write out to a wider cohort of people who could be eligible for the Horizon Shortfall Scheme. Right. So that has driven a larger number of people who are likely and expected to apply, together with, as you said, the overturning of convictions rather than waiting for people to go through the court case, where we expect more people to come through as a result of the overturning.
And I think if I understood you correctly, Mr. Criswell, you said that the money for lawyers is not coming out of that package. But do you have any indication of what the total cost of external lawyers is likely to be? Have you done any work on that?
I don't have that figure here. The £1.8 billion includes the redress costs, so the money that goes to the claimants, and the cost of their lawyers' fees within that. So the number that I mentioned earlier that's not included is the legal fees for the Post Office and for the department. We can have a look at what we've got information-wise and share it with you. I think previously we have been publishing on a quarterly basis legal costs spent to date, but I'll have a look to see whether we have any information on forecasts.
Thank you for that. I just say that, again, back to this, the adversarial nature of so much of this, it does seem like an old school system where one side is trying to maximise its claim and the other side is trying to minimise, which was the classic model for court redress. But it does appear that the department's paying for claimants to access legal advice and expert advice, and then another group of, again, government-paid lawyers, taxpayer-funded lawyers, are disputing that. Do you think that's a sensible use of taxpayers' money?
Just to be clear, we're certainly trying to. I know there have been criticisms about the adversarial nature of compensation process to date. We're certainly trying to make sure that isn't the case going forward. We do need legal advisors to make sure the scheme is run fairly and is run in line with the principles that we've published. But we're absolutely clear, and in that regard, I welcome the opportunity of this select committee to be clear that we want to avoid the sense that it is an adversarial process. And I hope in that way the confirmation that when requests for further information are being made, they're being made with the intention to try and help people be given a more generous settlement, not a less generous settlement.
Poynton?
This committee recommended to the last government that there should be binding time frames for each stage of the process. I'm just keen to get your take on that, and what are the virtues and pitfalls of that, because clearly what's been talked about today has been very much around getting swift justice, and that would allow both swift justice but also for claimants to see and understand where they are in the process.
I think the difficulty with binding timelines is that you risk excluding people, that people perhaps who have been deeply traumatised by the process, as we all know, many of the victims of the Horizon scandal have been, might feel that they couldn't put in a claim, that they might miss the deadline for putting in a claim. And I speak from my own experience.
Apologies. I meant within when a claimant comes in, so each stage of the process that there's binding time frames.
So if you take the example of someone asking for further information at day 36 on a 40-day process, the clock stops. People send in answers to what is sometimes 150 questions, and they then wait forever and a day until the answer then comes back from the Post Office. And what we're saying is, why don't you time-bound each stage of the process? We're not saying put a time-bound on the whole end-to-end process. We're not deterring new claims. We're saying at the moment people are playing games in the process, and we'd like to put a stop to that, please.
Well, I absolutely wouldn't want anybody to be playing games in the process either. I think we have tried to solve the problem that you perceive in a slightly different way by trying to essentially find ways to speed up the process, be it through the fixed sum payments, by working directly with claimants' lawyers, both on forms and the information that we ask of those forms. And we're also certainly trying to learn from the lessons of previous schemes in the way we've set up the most recent new scheme for those who had their convictions overturned, by being clear to people up front that if they tell us what they don't know, we will not ask for information in that space, to try and reduce the stress and essentially the re-traumatizing of those people.
Yeah, I think for those that go for the fixed sum, they can see the process play out. But I suppose it's for those that are going through a process and, as the chair said, restarting, that not understanding kind of where they are in that process. I think they need some light at the end of the tunnel, so that as they go through their process, they know where they sit within it and what their expectation and what is reasonable to expect. Because I think sometimes they feel, well, should I be getting something back by now? Should I not? When will I need to give more information? I think what they're looking for is that light at the end of the tunnel. So is there anything you can think about to give them that confidence?
I think the difficulty is that for the most complex cases, the cases are often very, very different. And I recognise acutely the need to try and speed up the process for people, particularly those who've been waiting for a very, very long time. And so generally open to suggestions from the committee as to what might, in an additional way, give confidence to people going forward. But we have tried to address, are trying to address in a very direct way, the concerns that people have had in the past, by working in, I hope, a very cooperative way going forward with claimants' lawyers to try and address some of the concerns that they articulate to us. And as you've alluded to already, the fixed sum payments again is an additional attempt to help a group of people get much quicker compensation much earlier in the process.
Sub-postmasters have no confidence in the Post Office delivering redress. Do you think they should be administering any of the redress schemes?
So I understand that concern. I suppose I have an answer in two parts to that. I think in terms of the situation now, the last thing we would want to do is to slow up the process, which would be the risk if you just said, okay, we're going to take the Post Office completely out of the picture at this point. That would undoubtedly slow down the process. What we are trying to do in order to make sure the process continues to move is to look at what else we can do to take some of the pressure off the Post Office. So, for example, the overturned conviction schemes, we're actively looking at whether that might be able to be brought in-house. We're also, in a very direct way, planning the Horizon Shortfall Scheme appeals process as to be separately administered by the department from the Post Office. But I think, and the Treasury have asked us to look at in time whether the Horizon Shortfall Scheme could come in-house. That's a very big ask, and if we did it straight away, would undoubtedly delay getting payments out of the door. But we are, I think, in a very direct way, trying to ease the Post Office out of some of the work, and I've certainly encouraged the Post Office to operate in a different way going forward.
So is there anything specific that you think you can do with them to improve the performance of what they continue to do?
So we've discussed the issue of the way in which the legal advice that they have accessed up to now operates, and whether there are changes that they can make there. We have encouraged them to write out to anybody else that they think might be the victims of the scandal in order to come forward. And we're talking to claimants' lawyers about what else we can do to make the post office run Horizon Shortfall Scheme work better going forward.
What's their advice been?
So there are things that, as we've alluded to, around the use of forms, around the use of the forms that are provided going forward. And as I say, we've introduced a fixed sum payment in the Horizon Shortfall Scheme in a very direct way to help speed up redress for those people for whom the post office has got the responsibility for running that compensation scheme.
We're also getting some help from them for the design of the HSS appeals system, where the claimant lawyers are saying they want something that's simpler than the current dispute resolution process that the post office is running.
I don't quite understand this, I mean, the HSS late claims, 13%, just 13% of those claims have been settled. And when Nick Reed went to the Wynne-Williams inquiry on the 9th and 11th of October this year, he said the post office shouldn't be running the HSS, and he thought Mr. Ricaldin would say the same. I just don't understand how you think it can go slower by taking the post office out.
Well, I think, as I made clear, I think we think that certainly the appeals process that we're in the process of setting up shouldn't be run by the post office going forward. We are actively working with the post office to administer the fixed sum payments, which is certainly, we believe, helping to speed up compensation getting out the door. And we will be working with the post office to see what other improvements we can make to the system. But we are also very directly looking at the issue of whether we could bring the whole Horizon Shortfall Scheme in-house. The Treasury have asked us to do that. But I think it's right that we start by looking at the appeals process, which will be which is part of the Horizon Shortfall Scheme process, but separately administered.
When have the Treasury asked you to finish that work by?
They haven't set a deadline.
Okay. Right, just a couple of final questions then. So the Chairman of the Post Office has just published transformation plan. Thank you for the statement that you made to the House. Do you know how much the transformation plan is going to cost?
There are, well, we're working through the costs of that transformation plan, both with the Post Office, in-house, and ultimately with the Treasury.
Okay. Will it be a bid to the comprehensive spending review from your department?
There have to be elements of it that are that we bid for to the comprehensive spending review. Some of the other aspects of the transformation plan, such as the consultative council with sub-postmasters, which is, I think, potentially a very significant step in terms of changing the culture of the post office and the way it treats sub-postmasters. That isn't a spending review bid. That they can absolutely do now.
If you can't source the money for this transformation plan, people say that the chairman, Mr. Railton, will leave. Is that what you think?
Certainly, up to now we've had very good discussions with Mr. Railton about his thinking about the future of the post office, and good conversations with his senior management team, and I would expect those to continue.
And then the last question from me is on Project Phoenix. So you'll know about Project Phoenix and the ITV investigation into Project Phoenix. This is a case where the Post Office has spent £865,000 investigating sub-postmasters' complaints about investigators. Do you think that was a good use of public money?
I think it's right that the Post Office looks at allegations of wrongdoing. I'm not close enough to the detail of whether that figure is accurate or how much they spent, but we have been encouraging the Post Office for a while to respond to allegations that have been raised during the Horizon inquiry to ensure that people who committed wrongs in the past no longer continue to work for the Post Office.
Will you give me a view then, perhaps in writing, about whether you think Project Phoenix was a good use of taxpayers' money?
Be happy to do that.
Okay. And do you think that the Post Office is still employing people who investigated sub-postmasters?
We have discussed this issue with the Post Office, and my belief is that the vast majority of those people who were involved in investigations have left the Post Office.
As you and I know, the implication of that answer is that there are still some people working at the post office who were responsible for hounding the sub-postmasters. Do you think it's acceptable that they're still employed?
Well, I think this is one of the issues for the transformation plan, because you have to have as I say, what we have been absolutely clear with the new management of the post office is that there has to be a fundamental change in the culture of the post office going forward. They subscribe to that ambition too, and that results, and that has to apply to all facets of the relationship with sub-postmasters, both in terms of issues around pay, but also in terms of issues around investigations when there are discrepancies.
Any of us can be confident the culture has changed if these investigators are still on the post office books?
I think there has to be a process of change within the post office. I think we're only in the very early stages of that process of change. We're going to continue to have very direct conversations with the chair and chief executive and senior management team of the post office about what that transformation means, both in terms of the day-to-day operations, but also in terms of what's gone wrong in the past.
I think those investigators are likely to still be in post at the post office next year.
I'm not going to comment on individual employees, but I would certainly hope that there is evidence of a substantial change in the way the post office operates going forward.
That concludes our questions. Thank you very much indeed, both to you ministers and to officials, for all that you're doing and for taking so long to patiently answer our questions this afternoon. That concludes this panel. Order. Welcome to the second panel of the Business and Trade Select Committee's inquiry into redress payments for the sub-postmasters. Thank you very much indeed for joining us today. We're very grateful for you sparing the time to come and give evidence. Can I just start with what I think should be quite a simple question? Do you think that the redress schemes are running fast enough, Mr. Cheshire?
I can speak to the GLO scheme, which I'm assisting DBT on. I think it is running at a good pace. I think we could go faster.
It's not running fast enough. Could go faster.
Could go a bit faster.
Okay, Mr. Watts.
So I help with both HSS and OC1. On HSS, it is not running fast enough at the moment. There are currently, I think you mentioned the number is about 1,600. The number I've got is about 1,800 outstanding claims there. The reason it's not running fast enough...
We'll come on to the reasons, don't worry. I just wanted to get that first baseline question. So you don't think that's running fast enough. Mr. Francis, do you think the redress systems are running fast enough?
Good afternoon. I can only speak to the GLO scheme as well. I think there can always be further steps to take to speed the process up. But on the GLO scheme, there have been 228 claims settled of the 306 submitted, so some progress has been made, but more can be done.
Okay. Mr. Watts, the Freedom of Information request that we saw published earlier this year shows that Herbert Smith Freehills has received £163.6 million in legal fees. That was up to March 2024. Can you tell us how much in legal fees in total have now been received from the Post Office and DBT in relation to the Horizon schemes?
So in relation to the Horizon shortfall scheme, the fees charged by Herbert Smith Freehills to date is £51 million, which I know is a very large sum of money.
£51 million.
It might be helpful if I put some context on that. Obviously, we've been working on the scheme for almost 5 years now. That £51 million includes 370,000 hours of work. 80% of those hours of work run out of our low-cost centre in Belfast. So if you do the calculation, the average is £137 an hour, which I accept again is a large sum of money, but I think compares relatively favourably with the kind of fees that the claimant lawyers would be charging. I accept it's a huge sum of money, but it is a huge amount of work that's been involved in the scheme over the last 5 years.
That 2,454 cases have been resolved, and the legal bill is £51 million. That implies that the legal cost per case is £20,782. Do you think that is a reasonable amount of money for the taxpayer to pay to settle one case?
So I think that again, you need to delve into the detail on that. So I think it's actually 3,000 cases have been resolved to date. But also what you have to take into account, that's not just assessing the cases, that was actually building the scheme in the first place. And in particular, the work that was necessary and was done in building the principles and getting those approved both by Post Office and by BEIS, as then was. And those principles have effectively been carried across and adopted by the other schemes as well. So in that way, they sort of set the precedent for the schemes going forward and was helpful, I think, in the way in which the other schemes were put together.
Well, 2,450 cases are the numbers that we have published from the department. 51 million is the bill. I come back to the question, despite all the setup costs, is £21,000 a case a reasonable number for the taxpayers to pay?
I think that's for others to judge rather than me, sir.
But I'm asking you.
I think taking into account all of the work that was done, yes.
You think that is a reasonable amount of money?
I think taking into account the work that was done, yes.
In addition to the 51 million, it looks like there is another 110 million of other cost. What was that 110 million for?
So there's also the GLO scheme. That, I think the cost in relation to that to date is about 13 million. Then the remainder of that number will include disbursements and VAT, but will also include the work that my firm did, which I didn't do, in relation to the public inquiry. And I can give you the breakdown of those costs, not now, unfortunately, I don't have them to my fingertips, but I'm more than happy to write subsequently to give you the breakdown of those costs, if that would be helpful.
And it would be very helpful, thank you. Most legal firms will have billing targets as part of their business plans. What are your billing targets for the post office schemes next year?
I don't have any billing targets for the post office scheme. So the way the firm would work is that obviously we set a budget as a firm, but we don't have targets for specific matters.
Okay, Mr. Cheshire, the last costs that we have in the public domain are 4.33 million for Addleshaws. I don't think that number is up to date. What's the up-to-date number?
That's the figure for the. That's a figure that's an estimate for the entire project for our work on that. Our figure on and that's on the GLO. Our figure. And I think you should have this because it's been provided to me as well. Our figure for the GLO work to date is 1.675 million, so £1,675,000.
Okay, and do you have billing targets for this work next year?
No.
Okay. Mr. Francis, the number that we have for Denton's is 2.52 million. Is that an accurate number for how much you've charged?
No, the total that Denton's has charged to date is around £840,000. We also have some additional disbursements where we operate the independent panel on the GLO scheme, where we have senior KCs, forensic accountants, such like, issuing binding decisions, and that sum is separate.
Okay, so I just want to get this straight. So we've got the biggest miscarriage of justice in British legal history. We've got redress schemes that are running so slowly that people are dying before they get compensation. Each one of you has said that the schemes are running too slowly. We've got legal costs of something like £53 million, costing the taxpayer tens of thousands of pounds per case. I mean, the blunt question I think the committee has got to ask is, are you not profiting from sub-postmasters' misery, Mr. Watts?
No. I think, again, it's helpful to dive into the detail in relation to what's involved. So first of all, the reason why I don't think the scheme is going quickly enough at the moment is that the original cohort of claims which came in when the scheme opened in May 2020, we were delayed in getting offers out on those because of the governance and the funding requirements of, as it then was, BEIS, which meant that the first offer couldn't actually go out the door until March 21, until all those matters were resolved. By December 22, 95% of offers had gone. So I think that once we got started with the original cohort, I think speed was, you can always be quicker, but I think that we were relatively satisfied with that. We then slowed down because whilst the scheme was then closed for 2 years until October 2022, it reopened again, and applications were coming in, I think, roughly around 20 to 25 a month, so not a huge number of applications, and they were being dealt with relatively speedily. But then what happened was the ITV drama at the beginning of this year, where in the 3 months after that drama was aired, I think we got between 1,100 and 1,200 cases in those 3 months, and at that stage we just weren't prepared for that number of cases. We then started to build up the team again to try and get through those cases, but subsequently what happened was the suggestion of the 75,000 fixed fee offer, which effectively meant that we were told to put on hold, I think it's approximately 1,350 of those cases, because it was expected or anticipated that those postmasters may wish to accept that offer, and therefore obviously there was no point in wasting money on assessing claims where the 75,000 may be accepted. So at the moment we've got approximately 450 cases where we think the 75,000 won't be accepted. We are working through those. A number of them are ready or close to going to offer. We think that assuming that the RFIs get answered in relatively good time, that we ought to be able to get offers out on all of those subject to unforeseen circumstances by the end of March next year.
Let me come back to this point. I mean, most sub-postmasters listening to this session will be frankly horrified that we're spending on average £21,000 on a case. What do you think is a reasonable legal cost for each case?
So we're not spending £21,000 on a case at the moment. I think that the way we try and...
They'll be looking at 51 million and dividing it by the number of cases. But we can argue the toss on that.
No, we don't.
The question is, what is the reasonable amount? What is the reasonable legal cost per case?
So what we're looking at the moment in relation to the 450 that we're looking to deal with, which are the most complex ones because we anticipate that they will be over 75,000 and a number of them well in excess of 75,000. I think we've agreed with Post Office that it will be £15,000 per case.
15,000. Extraordinary. Okay. Sarah Edwards.
Thank you, Chair. This is for Rob Francis. So, as claims facilitators and addendums, you've been called in previous sessions a highly paid postbox. Obviously, you mentioned that you've billed about 840,000. We've got the understanding that the contract is 2.52 million. Perhaps you can explain the difference or whether they're different. But what is it that you're actually doing to progress claims through that scheme? Could you explain more about that role and also just comment on the fees that you've charged so far?
Yes, so in terms of our role, it's important to emphasise we are an independent facilitator on the GLO scheme. So in that sense, we're not advising DPT or government on the specifics of an individual offer. Our role really is twofold. The first is to try and push along negotiations as quickly as possible, so we're chasing, making sure people are hitting deadlines, pushing both sides to try and resolve it quickly. But the second side of it is that we've set up an independent panel, and this is a range of different people. Senior KCs, we've got 4 different KCs available, senior forensic accountants, and they can issue a binding decision if the individual parties can't reach appropriate terms for the redress. As well as that, we've got the appeal function that was mentioned earlier, where if either side feels unhappy with the binding decision, they can refer it to Sir Ross Cranston, a retired High Court judge, to issue a further decision on that. So that's the role more broadly. In terms of taking on the point about the comments that were made at the previous session, that's not a description I'd recognise. There's 2 points to that. The first is that we do operate a portal, our electronic portal. There's 492 claims in the GLO scheme, and we're using technology to be as efficient as possible. So what happens is the postmasters, solicitors can submit the claim through the portal, and there'll be quite often a lot of evidence that goes with that. It'll be uploaded to the portal, and then that generates an automatic alert, and at that point it's the advisors to the government on the individual offers, Addleshaw Goddard, which Mr Cheshire's from, and they will then consider that and put together an offer. So we're not the ones putting together the offer. But that portal, I think, is important. It provides a rapid process to get the claims to the people they need to get to. There's 492 of them, so there's a lot of information. It stores all the key documents in one location for the parties. But it also provides live updates to all the claimant solicitors. So some of the firms are representing several hundred postmasters, and this gives them the ability to see in real time where each claim is at with the deadlines, and we're using it to chase the parties as well. Picking up the final point you asked about our fees, the distinction is that when this went out to competitive tender, that figure was the figure set by the government for the competitive tender. The amount that I gave is the amount we've billed to date.
Just to follow up on that, why do you think then that their description, their experience seems very different to the description that you've just given of these different component parts and cases and the like of it? So why do you think that their experience feels as though it is just simply a post box and that they don't have that understanding of the process?
I think the first thing I'd say is I fully recognise the postmasters want this resolved as quickly as possible. It's an aim we share as well. As the independent facilitators, we're trying to push things through as quickly as possible, so I recognise there's a desire to get things through quickly. In terms of the specific examples given in the previous session about the individuals, we went and had a look at those particular matters, and I won't talk about individual cases for obvious reasons, but we identified the issues on those two particular claims where an individual who wasn't from Denton had left an email address off an email, and so there was a delay for that period. That was picked up and resolved, and there's over 300 claims have been submitted, so I don't think those two particular instances represent the overall approach to the communication. But I do recognise the intent and the feeling, as you've said, that we need to be moving as quickly as possible and pushing. Denton's role is very much to push the parties. We're the ones that are butting heads. We're the ones that are issuing case management decisions. And an important mechanism of that is we do have the independent panel. So if the parties can't reach agreed terms, we have the ability to send it to senior KCs, senior forensic accountants, to issue a binding decision that government then has to pay that sum. And we're talking to the claimants all the time. So if it's something that the claimants want, we're very, very happy to move forward with that.
Thank you,
Thank you, Chair. So just building on that point, where do you think the bottlenecks or the barriers are in the system?
So in terms of, I can only speak to the GLO scheme specifically, in terms of that particular scheme, of the 492 claims, 306 have been submitted. So not all of them are yet in the scheme. And there's a good reason for that. The claimant solicitors are working hard to progress their clients' claims as quickly as possible. But it took a significant period of time for the post office to get them the evidence they needed to do so. Now that's been resolved. I'm not involved with that at all. We don't deal with the post office at all except funding platform. But as I understand it, that issue has been resolved. It has a knock-on effect now that the claimant solicitors need to put together the evidence. They need to get expert evidence in terms of forensic accountancy evidence and medical evidence, and then that gets put together and submitted. So I think we will see the rest of the claims come through, as I understand it, from the claimants' lawyers who we're talking to by the end of the year, which is positive news, and we welcome that. I think the other area that we're really pushing, and we've been pushing hard this both to Adelshire Goddard and government, but also to everyone we can talk to about this, is about just really turning around the offers as quickly as possible. They have the 40-day period, they're meeting that for the first offer, but it's also making sure that when the postmaster pushes back on that first offer for valid reasons, then the second offer comes out as quickly as possible. And I understand government is now setting a target for that as well, which is welcome news.
Antonia Bance.
Mr. Cheshire, claimant representatives have called your approach to evaluating expert evidence from sub-postmasters, such as psychiatric evidence, overly forensic in its nature. How do you respond to this?
I recognise that it's frustrating, and sometimes when we're making requests for further information on those expert reports. I know James Hartley raised that at the last session, and he gave the example of I think a 2 to 3 page letter in relation to a medical expert report. How I'd respond to that, and I agree it's a good example as well of our approach to requests for further information. But there's really three main points. First of all, the requests are really directed at the medical expert, who has been funded by the department with taxpayer money to produce the report. And where we have questions, we want to make sure that that report has covered the basic information that we'd expect to see to enable us to make an assessment of the severity of the injury, the personal injury, the appropriate treatment that DVT would fund, and also to provide a prognosis so that we can assess other aspects of the claim. And that goes to 3 heads of compensation, and we really are making those RFIs because we want to increase the offer, not to downplay it. First of all, on the non-pecuniary loss, personal injuries are assessed against something called the Judicial College Guidelines, and it requires an assessment of 6 factors, which we need to see covered in the expert report, because it makes a big difference to the award. At the bottom end of the scale, the award is something like £2,000, and at the top end of the scale, it's £140,000. So that's that element. Then there's the treatment costs, and often we're looking at psychiatric injury, so it's CBT, etc., other therapies, and then then some of the other those 6 factors that I mentioned also then run into the pecuniary loss aspects of the claim, and in particular the past and future loss of earnings. So it can have a massive effect on the award that we can offer, depending on what the evidence from the medical expert shows. And certainly I can say that it's not trying to reduce the offer. It's not intended to imply that the psychiatric injury was not caused by the post office. It's just trying to get the full information so that we can make the award. I can say in the vast majority of cases, DBT has accepted causation in relation to psychiatric injury.
The question wasn't just about psychiatric injury, though. It was about culture of disbelieving sub-postmasters, and I'd appreciate your thoughts on to what degree the GLO scheme provides for giving sub-postmasters the benefit of the doubt.
I think we do try to maximise the offers. We do try to give the benefits of the doubt, and we assess that, and we're looking at fairness across the board. So we have to consider fairness to the taxpayer, to the individual sub-postmasters, and to other and to consistency across the scheme, so that similar injuries, similar losses are compensated in the same way. And what I would add is that we quite regularly now make offers in respect of heads of loss that are higher than what's being claimed, and in some cases we offer compensation for something that hasn't been claimed because we've seen it in the evidence, but it's not been picked up by the claimant lawyers, and so we've made an offer on that head of loss.
Thank you. And in the last session, Minister Thomas said that he has made it clear that we want claimants to be given the benefit of the doubt and that offers should be as generous as possible. Do you think you're fulfilling that?
I do. I think we work very hard to do that. We advise DBT, we consult with DBT, and ultimately we're advising and they're deciding, but I think we are doing our best to be fair.
And in the answer before the last one, you mentioned the importance of value for money for the taxpayer. Do you think that's of an overriding concern to your firm in this process?
I think it's a factor. I don't think it's an overriding concern. I think at the front and centre of everything we do is ensuring that the sub-postmasters are paid full and fair compensation, and that is done as fast as we can.
I think the challenge that we've got is that when we look at the compensation number that's gone out the door, it's about 470 million. When we look at the total legal cost, it's about 270 million. So as of now, it's costing a fortune in order to get the redress payments to sub-postmasters.
I can only comment on the 1.675 million that my firm has billed on the GLO scheme.
The process you've just described, though, in answer to Antonio Bantz, to me sounds mind-blowingly complicated. How do you expect sub-postmasters have been to hell and back to go through that process in order to get the redress payment that they're entitled to.
Well, in the GLO scheme, they have the benefit of the advisors who are assisting them through that process. This is the process that's been set up.
I know that, but the question is, why has it been set up like this? Why is it not simpler? And I guess what we want to know as a committee is, what would you suggest in order to make it simpler and faster and to reflect the minister's steer, which is that sub-postmasters ought to be given the benefit of the doubt, not sent off to go and get complicated medical assessments, often for people who might be dead.
Well, I think the process was designed with in consultation with the JFSA, as I understand it. I wasn't involved at the time, but this is the process that was set up with consultation with the JFSA.
It's obviously not working, because you've all just said at the beginning of this session that the redress schemes are running too slow. So the question again is, what would you do to make it simpler now?
I think it's very difficult to make it simpler. These are complicated claims, and the GLO scheme is the only one that I can comment on at the moment, and it's a very ambitious scheme. It's moving fast compared with comparable schemes. I struggle to see how, without a sort of a fundamental redesign which wouldn't necessarily speed anything up, I struggle to see how it can change significantly. We are making good progress. We have, as at 31st of October, 295 offers have been made, 228 offers have been accepted, and 221 claims have been paid out in full.
You don't think it can go any faster, and you don't think it can be any simpler?
I think it can go a little bit faster, but I don't think it can be substantially simpler. I think these are complicated claims, and they're not. There's not a one-size-fits-all approach. I think James Hartley would agree with me that there isn't a formula for this. I think he said that in the last session. These are complicated claims.
Very good point.
Thanks, Mr. Cheshire. You said you're looking to increase the offer, not downplay it, but in our last session, James Hartley at Freeths told us that 27% of first offers made to his clients were for less than half of what they initially claimed. And that sounds like you're trying to write down offers, are you?
No. We are trying to reach a view, an independent. We are trying to reach a view on what the claims are worth, what's appropriate redress for the claimants, and advising DBT on the same.
In terms of motivation, and this is somewhat to follow on from Antonio Bance's question, do you see it as your job then to reduce the cost of the claims? Yeah. And are your team incentivised in any way at all to reduce costs?
No.
Okay, Mr. Weston.
Thank you, Chair. Mr. Watts, Herbert Smith Freehills were involved in the battle alongside Womble, Bond, Dickinson in the original Bates litigation. But you then went on to assist in the design of the Horizon shortfall scheme. It's a curious situation that you should have gone on to do that. In fact, the previous minister, Kevin Hollinrake, said he was astonished by that. Why did you not recuse yourself?
I think, first of all, and I've heard this and I understand the comments have been made, but I think partly it's based on a misunderstanding of what our role was on the GLO. So in relation to the original GLO, as you said, Womble, Bond, Dickinson were the solicitors on the record that fought that litigation. That litigation went badly wrong for Post Office from their perspective. I think it came to the correct outcome, but obviously it wasn't going the way Post Office wanted it to. So we were asked to advise on a strategic level. So we were one of two firms that were approached in April 2019 as to whether or not we could advise on a strategic level, and in particular how we could bring that litigation to an end. So our only role on the GLO was twofold. First was in relation to an appeal on some points of law in relation to the common issues judgment. That was probably about 2% of what we did, and that was really largely driven by Post Office needing some clarity around some of the things that Mr. Justice Fraser had found, because they were going to prove challenging to their ongoing operations. So that was a very small part. The large part of what we did was putting them in a position where they could settle the GLO, and what that very much involved was looking at the claims brought by the postmasters and trying to evaluate those and what they might look like at the end of the proceedings on the assumption that they would win. The challenge that we faced was that the details that had been given in relation to those claims were very sparse, because at that stage they were just looking at liability. They weren't really looking at the amount they could recover. They'd put in what are known as effectively just their estimate of what their losses were. So we did an awful lot of work trying to work out what their claims would be worth at the end of the proceedings on the assumption that they won. And that then gave us the ability, on behalf of Post Office, to go to Bays and say, we think this is what they're likely to recover at the end of these proceedings. Please give us authority to go and try and settle the proceedings up to this amount. That resulted in a mediation which went on for, I can't remember if it was 11 or 13 days, but quite a long time, involving 2 independent mediators helping us to come to a resolution. We did come to a resolution, and as part of that resolution it was agreed that a scheme would be set up, because it had been indicated by Sir Alan that he was aware of a number of other postmasters who had similar claims but hadn't felt able to join the GLO, and that therefore he wanted a mechanism for these claims to be dealt with. At that stage we didn't really have very much insight as to how many of these claims there would be. I think Sir Alan at this time mentioned about 50 or 60, but I asked Post Office how many do you think it would be, and nobody really had any idea. So part of the terms of the settlement agreement were effectively the bare bones of what became the Horizon Shortfall Scheme, and therefore I think that it was as a result of our involvement with the settlement, as a result of the fact that we understood the way these claims may be put, and the fact that we had the legal knowledge of the issues that would impact these claims, put us in a good position to be able to help with the scheme. There clearly wasn't any conflict, because our instructions on the GLO was to help Post Office to settle it, and our instructions on the Horizon Shortfall Scheme have been and continue to be from the outset to help Post Office deliver full and fair redress, and that's what we've always been instructed to do, and that's what we always tried to do.
For that, for an outsider, it would seem that I understand the points you're making. I don't necessarily agree with them, but I'm interested by them. To an outsider, it would seem you had skin in the game. You were disposed to the client, the Post Office, in the first instance. I want to know, at that time, what did the government minister say about your involvement in establishing this?
I would have had no discussions with the government minister, so I wouldn't.
They weren't involved. It was just.
I can't answer that question. Maybe somebody at Bays or somebody at Post Office could answer that question, but I wasn't involved, so I've got no.
Who would it be in the Post Office, do you think?
I don't know, I'm afraid.
Thank you.
And this is a question to Mr. Watson. The Horizon Shortfall Scheme does not provide legal support funding for claimants prior to the outcome of the full assessment. Why design the scheme in such a way?
So, and I've heard this phrase on a number of occasions. At the end of the day, obviously, the decision wasn't mine as to whether or not legal advice would be provided for or not. So the only things that I can tell you to sort of help you work that out are, it was very clear, again, coming back to the settlement of the GLO, one of the things that was clear from Sir Alan and those that were involved in settling that they would prefer something which didn't need legal input, which was simpler for postmasters to be able to access and not have to spend or large sums of money go on lawyers. So that was one factor. As to other factors around costs, etc., I wasn't party to any of those discussions, so I don't know. It wasn't my decision. It would have been a decision taken by Post Office, I assume, alongside Bays. The only thing that is worth adding is that postmasters do get the ability to get legal advice once they've received an offer, and that was the way the scheme was designed. It was designed to try and allow postmasters to bring claims without the need of legal advice at But once they had an offer, they would have the ability to go and take legal advice, because we felt that was very important to be able to explain the offer to them. And if they were to accept the offer, they would be giving up rights. So therefore, it was very important for them at that stage that they should have the ability to take legal advice. It's interesting to note, and that, as I understand it, those that did get the offer, only 8.4% actually took up the offer of taking legal advice at that stage. So I'm not sure, you'd have to ask those people why they didn't take up the offer of that legal advice. But I think that sort of demonstrates that they did understand the offers, that they didn't feel the need for legal advice at that stage, and that therefore that might be an explanation as to why they were happy to proceed as they did.
And do you consider at the time whether it was fair to insert complex legal terminology in assessment offers to sub-postmasters, many of who would lack legal representation?
So again, and I understand where this question is coming from, because I've heard these comments made previously. And there are two things. Having heard the comments before, I thought, well, I should go back and look at what was done. And two things. First thing I looked at was the application form. So I don't know if members of the committee have looked at it, you can access it from the website. It's actually only 5 pages of questions, which I think are written in fairly non-legalese. But the other issue that I think people have raised is the RFIs. So there's a balance to had. You could try and make the application form simpler, but there's a balance to be had between asking for enough information on the application form. And you have to ask things: name of postmaster, did you have a contract with post office? When did you run your post office? What shortfalls did you suffer? Was your contract terminated? The basic questions you have to ask to be able to work out what their claim is and what it would look like. The RFIs is more challenging, because what you're trying to do then is build on what they've already told you and try and work out what their claims are. Because, as you said, we've pointed out, they're not getting legal advice, they're not lawyers, this isn't their area. So what we worked alongside the independent panel to design the RFIs, to try and put them in language which we believe would be as straightforward as possible. It's never going to be that straightforward, because we are dealing with legal concepts, so we're trying to explain them in a way that people could understand. And we tested that out. So in relation to the independent panel, whilst 8 of them are lawyers, 8 of them aren't lawyers. So we tested it with the panel as well, but we also tested it within post office with people that aren't lawyers but know postmasters and know how postmasters think. And we tested them to see if they thought they were clear enough for postmasters to be able to understand. So that's the way in which we worked out the RFIs. Obviously, depending on the heads of loss that you're claiming, you'll get different sets of questions. So if you're claiming shortfalls, you'll get sets of questions in relation to those shortfalls. How did you repay those shortfalls? How often did they occur? Is there anything else you can tell us about those shortfalls? If they're claiming for loss of a business, you'll be asking questions such as, when did you buy your business? Can you remember how much it cost? What did you sell your business for? Those are the kind of questions. They are put in that straightforward way. And I don't know, if it would be helpful to the committee, I could probably send you an anonymised version of an RFA so you could see it for yourselves. I don't know whether that would be helpful or not.
Very useful.
But I think that I'm not saying we're always right. There will have been occasions where we did overcomplicate it. We weren't trying to. And I understand the point, I think, that was made earlier, that obviously some of the postmasters, English won't necessarily be their first language, and perhaps we should have done more in relation to give them assistance. There is an email helpline and there is a phone helpline, which I think that we ought to do more to encourage them to use.
We're not trying to relitigate the
No, sorry.
Because Sir Wyn Williams is doing that for us all. But we are wrestling with Mr. Cheshire's testimony that he doesn't think that this process can be simplified or accelerated. So we are looking for things that we can do to improve it. Mr. Weston.
Just one question, if I could. It really goes back to the chair's one of the chair's first questions, which was about billings, and I guess it's a naive question based on my limited understanding of how law firms work. But you said you couldn't, you had no idea what the billings would be related to this work for the coming year. How can you resource what you need to do if you've got no idea? How are you estimating the need for this financial year with your business? So, Mr. Cheshire first.
I think, just to clarify, the question that I was answering, I thought anyway, was do I have any billing targets to reach, or am I incentivised to reach a billing target? And I'm not. But in terms of allocating resource, yes, we monitor what the cases are coming in. We have regular dialogue with Freeths and the other major firms who are submitting claims, and we have scaled up appropriately. So the last time I was before this committee in February, we've actually trebled the size of the team in reaction to knowing that more claims were coming in as the claims input has accelerated. So we absolutely do that, and we track the 40 working days. We work out how we allocate the cases, etc. That's all managed.
That's for this financial year, Mr. Watts.
So it's a similar way, and we don't, as I said, we don't have budgets for this case. And one of the advantages of using our low-cost centre in Belfast is our ability to flex up and down with the team. So, for example, when things were much quieter, when we were only having 20 or 25 applications a month, the team went down to a much smaller size of possibly 20, 30 individuals. We've now built the team up to 80 people to try and deal with the number of cases we've now got. So that's how we managed to resource it, and the fact that because we've got a large low-cost centre in Belfast, we are able to flex up and down relatively quickly. We do have regular...
You estimate it, don't you?
Well, we have regular discussions with Post Office about what they see as the likely trajectory going forward, and they tell us what they think the cases are going to be, and then we try to build the team to meet the cases. But for example, at the moment, because of the fact that the 1,350 cases are on hold, we are at a point where, unless something happens, we're going to have to take people off the team because we can't have them sitting there doing nothing. So we do flex up and down. Ideally, you want to keep the same people doing the cases, because obviously the more cases they do, the more familiar they are with the issues, the quicker they can do them.
So our role is very different. We're not having case advisors going through putting together offers. We do forecasting within our team, make sure that we've got a sufficiently large team in place to work on this, work with legal project managers and other experts to make sure that we've got a big enough team. And certainly I could say that we're turning things around within the day we get them or shortly afterwards. So for us, team size is an issue. We've got a lot of extra capacity out there across the country we can bring in to use on this as well.
So those forecast figures might be given to DBT via Post Office or direct?
In terms of our forecast, it's more about making sure we've got a team in place ready to support the facilitation of the claims and the GLO scheme.
Okay. Thank you very much indeed. You've told us that none of you are very happy with how fast this redress scheme is going. You've told us that it's not clear that it can be made to go any faster, and you've told us it's extremely expensive. So that's extremely useful testimony to the committee as we frame our recommendations. Thank you very much indeed for your time this afternoon and for the candour of your evidence. That concludes this panel. Order. Order. Welcome to this third panel of today's Select Committee hearing on fair and fast redress for the sub-postmasters. I'm very grateful to you, Mr. Railton, for joining us, and for Mr. McCallum for coming back. Mr. Railton, perhaps I could just start with the basic, simple question we all want the answer to. Are the redress schemes working fast enough, or do they need to go faster still?
I think they need to go faster.
You've come in as a new chair. Mm-hmm. You've got a great background in some great businesses. As you've come in and had a look at these schemes, what were your observations about the things that were going wrong?
So I joined officially on the 24th of May, so I've had a few months now to consider this. My walking-in hypothesis remains the same now, that the Post Office should not be dealing with redress. Not from it.
Is that still your view?
Yeah, very much so. However, I think we have to be pragmatic. And as the Minister said earlier, we have to be pragmatic because we don't want to slow things down. And the way I've been thinking about this is there's two dimensions to the redress schemes. There's volume and there's complexity. And I think in order to be pragmatic, it's probably best that the post office keep on to the volume, but not those things that are complex. In other words, for example, the 75,000 schemes where the decision to pay that is relatively straightforward. However, the complex schemes should all be with DBT. That's really a long-winded way of saying that in an ideal world, it'd all be with DBT. But to be pragmatic, let's think about dividing the schemes into those two dimensions. Low complexity, high volume with the post office. High complexity, lower volume with DBT.
And who should decide what is simple and what is complex?
I think the facts should decide for themselves, really. I mean, if you look at the schemes, and Simon perhaps can offer some more details, but the £75,000 fixed offer is relatively straightforward because, as I understand it, we need to find one shortfall, and then based on that, we will generate a cheque for the 75,000. That, to me, is a process that seems to be, I think we can automate it. Simon and I talked about this, and make it very, very quick and very, very simple. And it doesn't need a lot of judgment because the rules are very, very clear. So if we can do that and focus on those low complex, high volume cases, I think we could clear quite a lot out from the post office. And I think DBT, given they are ultimately decision makers, are better placed to deal with the complex issues.
Do you have enough data to be able to estimate how you would break down the 1,762 claims that have been received? Only about 13% of those have been paid. These are the late claims. What would be your guesstimate as to what fraction of those claims would be simple and what would be complex?
I don't know. I'd have to defer to Simon. Could you answer that, Simon?
Yeah, I think the vast majority, you could say, would be simple. I'd say the vast majority on modelling, given the £75,000 opportunity, on modelling is predicting a certain level of claims under 75,000, where we are deeming any claim over 75,000 to be more complex.
When we say overwhelming majority, is that 60, 70, 80, 90%?
I think the rule of thumb is 80%, isn't it?
So the modelling is saying between 80 and 85%, but we don't know, Chair, to be absolutely clear. Of course we don't know, but that's what the modelling is. And this is built on facts. The average payout settlement in the HSS is 47,000. Mm-hmm. So if you compare that to a 75,000 automated, very quick process, then you would see an incentive for the 75,000 to be accepted. And therefore, some of that modelling is based on that fact and trajectorying that out. I can give you some more figures around that if you so wish.
Mr. Railton, you presumably had time now to present this idea to ministers.
I've had discussions with ministers, yes.
And what have they said?
We're in discussions.
So there's been no conclusion or decision yet back from ministers about the Railton plan?
No conclusion as yet. But conversations continue. In the meantime, we are working out from the post office perspective how to automate the process, regardless of what moves. So the thinking on that is well progressed. We're thinking of, well, not thinking of, we are thinking about who we would use to help us to automate the whole process end to end. So basically, letter comes in with a shortfall or claim comes in with a shortfall, we can automate it. I mean, quite frankly, we're working on a database from 2014 backwards. Yeah. So somebody should be able to write database queries for this. We don't need people looking for this. In my mind, it's quite straightforward.
And so in your discussion with ministers, which you are discussing, what are the stumbling blocks? I'd have thought ministers would just embrace this with open arms.
I think it's the balance between change and speed. Nobody wants to slow anything down. Everyone wants to speed up where possible. And let me be clear, the automation of the 75,000 process, nobody's slowing us down on that. We're going to do that ourselves. I just think a line needs to be drawn on that balance of complexity and volume. I think those are the key dimensions. And I don't think the post office should be dealing with anything that's complex.
I mean, given the number of late claims that have been received, given the number that have been paid, 80% of that, I mean, that would imply that you could basically pay out over 1,200 cases pretty quickly.
Yes, absolutely. And moreover, we're expecting thousands and thousands of claims very soon. So we have to set ourselves up for success and automate the process as best we can.
Very useful. Thank you. Antonia Benz.
Thank you, Chair. So how much has been spent to administer the schemes and on external lawyers?
I don't know. I'll have to defer to Simon.
Well, in terms of, I mean, you've got the figures from the legal teams in terms of how much is it on the scheme. So this is all ring-fence funding directly from government. So this does not impact on redress. So you've got a figure of about 160, 170 million on in terms of HSF's costs.
Can you say that again, so I'm just slightly slower?
Apologies, Chair. On the HSF costs, Herbert Smith Freehill's costs, to remind members of the committee, they run the back office for HSS out of Northern Ireland. So their costs